Okay, I'm going to turn on the recording. Okay, great. So good morning, good afternoon, everybody. Thank you for joining. We greatly appreciate that you found time from your busy schedule and joined us today for a very interesting talk by Dr. Aeraj Ul Haque. He is our esteemed speaker today. He's going to talk about the topic of patent filing from science to law. And he'll be covering some of the points. For example, find your passion. You will love your work if you have a passion for it. It's never too late to rediscover a field that interests you. Patent attorneys are generally scientists or engineers. Any human-made thing is patentable. A patent does not give you the monopoly over the technology, but allows you to prevent others from producing or using it. This talk will be especially beneficial for those students and their parents who are interested in exploring the patent attorney profession. This session will also be of interest to those planning to file a patent to copyright their work. Today's webinar is a result of a collaboration between STEMatters and the Young Professional Society. STEMatters, our organization has a vision and mission, and our vision is to enable students to innovate, invent, and deliver quality solutions to contemporary challenges. And our mission is to inspire students to excel in the areas of science, technology, engineering, and environment matters by nurturing their critical and analytical thinking skills. Young Professional Society is based off UK, our sister organization. Their mission is to bring to the forefront a more progressive, accomplished, and enlightened younger generation of people who will be the representatives and leaders of their communities and who will contribute positively towards the wider society. Let me now introduce you to our amazing speaker, Dr. Aeraj Ul Haque. He earned his doctorate in agricultural and biological bioengineering from Purdue University. He's a patent agent with Foley and Lardner LLP. He offers an interdisciplinary background in mechanical, agricultural, and biological engineering, having a broad knowledge of business development, entrepreneurship, patent analysis, patent drafting, and IP due diligence, intellectual property due diligence. He's extensively experienced in biomedical diagnostics technologies, agriculture technologies, biosensors, nanotechnologies, detectors, microfluid, battery technologies, and many others. So with that, thank you again, Dr. Haque, for joining us. We greatly appreciate you gave us time today. So over to you, Dr. Haque.
Oh, thank you so much, Shakil Bhai. Thank you so much, Dr. Iqbal, for inviting me over. This is a great honor to be able to talk to all of you. My talk is going to be from science to law. I'm going to try to give like a brief overview of, how I came to be where I am today, and then maybe talk a little bit more specifically about patent, filing patents and some of the more intricacies on a very high level about the patent process. So my story, I'm originally from Karachi. I grew up over there. I did my bachelor's in mechanical engineering from NED University of Engineering and Technology. So like, a lot of other fellow students at NED, my dream was to be able to come to the US, get a master's over here, and then make a career in the US. At that point in time, during my undergrad, I saw myself as maybe doing a master's in like hard mechanical engineering and finding a career in the automotive industry, maybe be an employee at GM or Ford, and that was kind of my small dream, and that's all what I thought about. I was very fortunate to get admitted in Purdue University in the School of Mechanical Engineering. When I had no idea what a Big Ten school or a top university entails in the U.S., but when I joined, I started as a master's student in the Department of Mechanical Engineering at Purdue. I found out that when I started in 2003, all the rage in the research over there was focused on nanotechnology. Nanotechnology was the big thing. I needed, very frankly, I was looking at an opportunity to get some kind of a research assistantship or teaching assistantship so I could fund my education. Like most other Pakistanis, you don't have a lot of money. You want to find some source of to some monetary source, and for most grad students, it's becoming a research fellow in one of the research, with one of the professors, so your education can be financed and you can earn a small living while doing your education. So nanotechnology was a main thing. I looked around and finally, I found an opportunity with Dr. Rashid Bashir, who's also Dr. Paul's mentor, at Purdue, to pursue a master's with research focused on nanotechnology. So during that time, I learned something completely new. I went into, learned about microfabrication, how you make silicon microchips, which was completely not my area. I was planning to build cars, but now I was looking at, like, from the macro big cars to like micro and nano technologies. How do you make microchips? How do you use them? How do you apply them to do biological research? During that time, I came across a professor in the Department of Agricultural and Biological Engineering. His name was Marshall Porterfield, and he was doing working on a project for NASA, and he needed somebody who could help him make micro or nano devices, what we call micro electromechanical systems, or MEMS devices. And I think that was a turning point in my career. When I joined the project, I had no idea. The final deliverable of the project was you were going to take this experiment to a NASA zero gravity flight called the NASA Vomit Comet, and I will get an opportunity to fly on it. So what you see on the right is the NASA Vomit Comet. It's basically a flight which flies like a roller coaster, and as it reaches the top, and when it goes up at a very steep angle and then comes down, at the apex of that curved path, you experience a period of like 30 to 40 seconds of microgravity, and that's where you run the experiments. So that picture is not upside down. That's me floating upside down in the NASA Vomit Comet. This is 2006. You can imagine a guy from Pakistan who had to pass through tons of extra security clearance, actually flying on a NASA gravity flight. That was really just opened up my eyes to what opportunities existed. And I decided that I wanted to pursue a PhD at Purdue. So I transferred from mechanical engineering. Now I transferred over to the Department of Agricultural and Biological Engineering to really move forward with the work I'd done in my master's, a lot of it with NASA. So now I got a NASA fellowship. On the left, you see kind of, a very overview of the experiment we had. If you can see my cursor, I'm not sure if you can see my cursor. But basically what we made was a microchip which could measure changes in behavior of single cells in microgravity. And basically this thing that you see in the chip itself was as big as a penny, and then it's mounted in the circuit board. It's then connected with electronics, and you have a complete control system. So a lot of my work during my PhD focused on that. Some of my work, actually, some of my later projects at the tail end of my PhD and then post-graduation from Purdue actually were flown aboard microsatellites and sent into space. My professor tells me, my professor Marshall Porterfield, he became the director of the NASA Biological Sciences Division for 4 years, and he ran the Twin Studies program with astronaut, Scott and Mark Kelly. He tells me some of my initial research has now found its way to the International Space Station experiments running over there. So you can imagine that was, really a high point in my career. My dream was to become a professor. The recession hit in 2008, and then, things became difficult for a lot of graduating PhDs. I decided I was very lucky. I got an opportunity after my postdoc to I got a director's postdoctoral fellowship at Argonne National Laboratory in the suburbs of Chicago. This is like a Department of Energy large laboratory. I think our claim to fame is we have at Argonne we had we have an accelerator like a cyclotron, which is primarily used for imaging. And some of the work they've done is, if we talk about the current circumstances, the imaging the structure of the COVID virus. They've also done imaging of other structures and really complicated work. The work I was doing, I started doing at Oregon was, again, continuing some of the work I'd done in my PhD, making biochips and biosensors for biological research. Then during that time, we found a collaborator. We got an idea of why idea of or a problem in the veterinary space. Cows get sick. Milk industry is a multi-billion-dollar industry. When cows get sick, their milk degrades in quality. Without going into details, that degradation in quality affects the payment the farmers get for their milk. Um, and that is directly related to how the cows are getting sick and what they're getting sick with. So we came up with a simple technology where you can pour milk in a simple microscope slide essentially, and that had uh, biological molecules which would light up and show you what disease was infecting the cow. And based on that, you could decide what to do with the cow, mitigate your losses. I think my claim to fame was I started, I think, pretty much the first postdoc to start a startup at Oregon National Laboratory called Site Diagnostics, with a couple of partners from the University of Chicago Booth School of Business. We were fourth place runner-ups in their business plan competition. I worked with the company kind of on the side for about 1 year. Eventually, the company tanked because we hit a major technological hurdle. But regardless, that experience. And I recommend everybody, all young people, if they get an opportunity, particularly early on, as early as your undergrad, get try to launch a startup. Having your own business, running your own business, particularly in the high tech sector, I think there's nothing more rewarding and nothing more educational than that. In any case, I by that time I wanted to get out of hands-on research, and I was looking at various career opportunities, and I decided eventually to pursue patent law. People don't realize all patent attorneys are generally scientists or engineers because patent law is very technical. Currently, I'm a senior patent agent and patent law clerk at a large law firm called Foley and Lardner LLP in its Chicago offices. If a PhD wasn't enough, faith would take me that now I'm pursuing a law degree from Loyola University of Chicago while doing my job. Um, my Some of my major clients, I do a variety of work in a variety of areas, but some of my, again, because of my background in mechanical, masters in ABE, I can cover a lot more technologies than most people. Some of my clients are Cummins, low hardcore diesel engine manufacturer, maybe self-driving vehicles. I represent Oregon National Laboratory. Again, that's a very different kind of work, materials, nanotechnology. I also do a lot of work for University of California, the entire regions, UCSD, UC Davis, some other universities on mostly biomedical stuff. And there's NYU, which is again very a variety of work I do for them. So with that, that pretty much sums up my background. So let's move on to intellectual property. So patents are a subset of property called, of law, which fall within the auspices of intellectual property. As the name suggests, it's intellectual. It's like actual property. In property, you have fences which mark the borders of your house. In intellectual property is you have also have fences, but they are invisible fences that mark the boundaries of an intangible idea or some creative concept or some new technology. The idea behind this thing is, our country uh, wants to reward innovators. I mean, it's this entire country is a capitalist country. Our goal is to reward people for the work they perform. The concept of intellectual properties, by giving inventors or artists or creators rights over the intellectual work, you are rewarding them by providing them the rights. It provides you the opportunity to obtain monetary benefit. So patents, you can prevent other people from using it if you have a patent on something. And if that person wants to use your technology, people have to pay you. You can also build a company around your technology on patented technology. And hopefully, if you have strong enough patent protection, people will not be able to do the same thing. So it's kind of a monopoly, but not really, because people can then build off your technology and make new things. They just can't do the exact same thing or similar thing from to what you're doing. So what are different kinds of intellectual property protection that's available? The first is trade secret. So a trade secret provides protection for valuable business information, and it's how long can you maintain a trade secret? Well, as long as you can maintain that a secret. So why would you want to maintain a trade? Why would you want to have something which is a trade secret? Generally, you want to keep something a trade secret if you're concerned that it's something that can be easily reverse engineered, or somebody can, if they know what the core idea is, they can easily build off it to make variations that you won't have thought about, or that those are not protected. So some of the things that are famous trade secrets is the Google search algorithm. I mean, Google has tons and tons of patents, but the core algorithm that Sergey Brin and Larry Page, that they developed, that runs the Google, that's a trade secret. They've never disclosed a core algorithm. The Coca-Cola, formula, that's been a trade secret for about 100 years. So they can keep it as long as there's very serious protection around the Coke formula. It's said that there's a vault beneath Coke headquarters where the actual formula is kept, and maybe only the family members of the original owners, or I can't remember exactly, but very few people have actual access to that secret formula. And you can very well imagine, I mean, that formula is what gives Coke its unique flavor. I mean, for all we know, it might have some addictive thing in it, but that's one thing. WD-40, supposed to be some kind of fish oil, but WD-40 is still a straight secret. I mean, what goes inside this magic thing, which can, open creaky doors, to some people have claimed can also cure back pain. God knows, but that's a trade secret. Now, Listerine was a trade secret. So the the formula that went into Listerine remained a trade secret. Funny thing is, Pfizer, I think, purchased the rights for the trade secret and started selling Listerine, and they paid about $22 million in royalty for the Listerine formula. Eventually, the Listerine formula became public information. I don't know, it was reverse engineered, or it got leaked, or whatever happened, but eventually came to the public domain. And Pfizer eventually had to say, file a lawsuit saying, we don't want to pay more royalty because it's now longer a trade secret. So, again, I mean, now whoever made Listerine or their descendants are not getting any more money out of it. So you can imagine, how trade secret can be helpful. Second type of intellectual property protection is copyright. So this protects original artistic work that is fixed in the medium. So work has to be original, new, and then it has to be fixed. For example, fixed means it has to be in some kind of a tangible medium. For example, take Harry Potter. I mean, there's I'm pretty sure various amounts of copyright around Harry Potter, the books, the movies. They're all, movies are on CD or on a hard disk. The books in physical media, the characters, how Harry Potter looks, all those things are copyrighted. Statues, the Statue of Liberty was copyrighted by Frederick A. Bartholdi in 1876. Now, one of the things to note is the term of a copyright is 70 years from death of author. So particularly for artistic works, this can be significant, because think about Elvis Presley. I mean, Elvis Presley maybe died in mid-1940s. His heirs, they can, copyright, like actual property, also transfers to your heirs apparent. So his heirs might be still earning money from any royalty income due to copyright surrounding the Elvis Presley brand, and his image, his likeness, and everything like that. In this case, the Statue of Liberty is no longer copyrighted because it's been more than 70 years since Bartholdi died. Funny thing is, the United States Postal Service issued a stamp with what they thought was an image of this Statue of Liberty that you see on this slide. Unfortunately, there's another Statue of Liberty in Vegas, which was, I think, copyrighted in '96. And that that has a separate copyright, and they unfortunately posted that image of that Statue of Liberty, not our famous Statue of Liberty in New York, and they got sued, and I think they lost. So copyright protection, again, another very important thing. Third type of protection is trademark. This protects words, symbols, even colors. Colors can be protected associated with a particular product. And the term for that is, and how long can something be a trademark is till the mark remains in commerce. That is how long. So think about the Nike swoosh, all these brands you can easily, correlate to, you can relate to them, the IKEA symbol, the IKEA logo, Kit Kat logo, but then it can also be color. Like a particular color can maybe be associated, be a trademark for a particular thing. Now, the key thing with trademark is that a trademark is valid unless, people don't relate the product with the trademark. They think about the company when they look at a particular mark. So for example, Velcro. Now, Velcro is used to be a trademark. So when Velcro initially came, I think they wanted to call it Curvy Derby or something. I don't know, some really funny name. But Velcro, we think about Velcro as that technology. Velcro was actually the trademark for that technology. And it became so commonplace that people started associating the name Velcro with that product, not with the company that made it. And that no longer is now a trademark. Similarly, Thermos. Similarly, Xerox might be at risk of, Xerox is a trademark, but if we all keep calling photocopies a Xerox, make a Xerox, it eventually might lose its trademark value. Finally, let's come to patent law, patent protection. Patent protection protects new inventions or designs. So this generally, when you talk about patents, you're talking about in very layman terms, a product, something which is tangible, which performs a certain function, and you want to protect it. But there's also design patent. We'll talk about it. So the term of a patent is 20 years from the first filing date for a utility patent, and 15 years. First filing date means when did you file the application with the US Patent Office. And for design patents, it's 15 years from issue. That is, what date was the patent issues. These are two separate categories of patents. We'll talk mostly about utility patents, but maybe talk slightly about design patents. So what is really patentable? Anything human made, even if it's a living thing, can be patented. Four major categories: process, for example, a method of doing something; a machine, that's pretty, cars, individual subcomponents of cars. Manufacture means something that you actually have made. Composition of matter, think about drugs. Maybe the Pfizer vaccine is a composition of matter. I don't know if they filed a patent around this thing. They might have filed a patent around the composition of the vaccine. Maybe the method of making that vaccine. There's a unique method with the mRNA technology. Maybe if they made a new machine to make it, they can file a patent on that. What is not patentable? Abstract ideas, laws of nature, natural phenomena. And you would be surprised how many people end up filing patents on these things. So what would these be? Laws of nature. So suppose, I want to patent gravity. Well, that's a natural phenomenon. You cannot patent gravity. People try to file patents on, a perpetual motion machines. That is something which remains in motion, and that every year maybe you receive 1 or 2 patents in the patent office, and that's an abstract idea. It's really not practical. Maybe some other things like very derogatory things or something might also the patent office might object to. This is what cannot be patented has gained a lot of importance with some case law. I'm not going to go into that, but is software patent. So if you write a patent on a software and you write it in a way that it appears that everything that's happening is within the processor itself, a patent office can come back and say, this is a mathematical concept, an abstract idea, and you can't really patent something which you can do in your head. And that's where, lawyers make a lot of money, and they know, ways to write a patent to make something which would appear non-patentable into something which is patentable. So let's start with design patents. So design patents protect the ornamental design. That's the aesthetic outlook of something. that's protected by a design patent. It cannot protect something that is functional. So let's talk about, let's say a famous patent is, these are a design patent only has pictures, maybe a few lines of sentences, but this is the main patent. This is the Apple iPhone, maybe 5S or the series before the 6, maybe even 6S. But before you got rid of the home button in Apple. And you can see what the patent is you're showing various views of the patent of the product, and you're just patenting the aesthetic outlook of that product. That means how it actually looks. If something is functional, um, and basically you design something to look a particular way because it serves a function. Let's say the design of a car, how a car looks. We fall in love with cars because a lot of times of how they look from outside. um, that is of course a design concept that can be a subject of a design patent. However, if you maybe added like an airfoil at the back, the airfoil performs a certain function of reducing drag or in pushing the car, changing airflow so the car is pushed down and it doesn't, at high speeds doesn't turn. So there's a functional aspect to the airfoil as well. But if you design some novel feature or some new design to make it look cool, which really doesn't affect the functionality, it might be patentable. You might be able to get a design patent on it. But if it performs a certain function, let's say if you wanted to, in this case, there could be an argument that the curved corners prevent dings from happening when the phone falls down. But the patent office didn't think so, or maybe nobody either I contested this way. Design patents became really famous a few years ago in the battle between Apple and Samsung. Samsung, the original Galaxy phones, apart from the home button being a square, looked very similar. If you look, to the point that people could start getting confused between the Samsung original Galaxy phones and the iPhone 5, and there was a big battle, and Apple got awarded $2.3 billion in that lawsuit, which lasted numerous years. So you can imagine that and with Apple, what really drives is how the thing looks. I mean, its functionality, of course, but the look, how its icons look, all those things can be, they don't perform they perform a function, but there are many ways to do the function. The particular look doesn't matter. So these can be important, particularly if your design is what sells. Coming to utility, this is what we think of when most people think of patents, or utility patents. So a United States patent is a limited grant from the US government to an inventor, giving the right to exclude others from making, using, offering for sale, or selling the patented invention in the US, or importing patented invention into the US. So the key word here is to exclude others. It doesn't give you the right to make the technology. It gives you the right to exclude others from making, using, offering for sale, or selling the technology, or bringing it into the US. So it's not a right to use it, just a right to exclude. There are two kind of patents, and I think this is an important point to remember if you want to remember anything. There's a provisional patent, and then there's a utility or non-provisional patent. A lot of people say, I filed a provisional patent. Well, a provisional patent is really just a placeholder in the patent office. Something that is very important in patent law is what date you file the application, because anything before that date can be used against you in examining your patent. So if your technology is half-baked, or it's very important, or you have a meeting with a potential partner, but you want to have a patent around the technology and there's not enough time, or it needs a lot of more development, instead of filing a full application, which is half-baked, you file a provisional application. It gives you 1 year to file a full patent application. The provisional patent is not examined. It's just you get a serial number from the USPTO, the United States Patent and Trademark Office. Your clock starts, file a full application within 1 year. If you don't, you lose that date that you file a provisional application. Doesn't mean anything. You can file another application. It's just what date, what is the date before which something can be used against your patent. You can think it can become really important when you have a highly competitive market. Let's think about Tesla Rivian, GM is making self-driving cars and electric cars. There must be a lot of competition. So there's a lot of rush in filing patents, because if you know that your competitor is also working on similar technologies, you don't want them to file a patent first. And now in the US, it's what we call first to file. That is, whoever files the first patent, original, which you originally came up with, they have the superior right on it. Then you have the utility non-provisional, which is the actual patent, and which is then examined, and that's what we think about when you think about patents. So utility patents, these are basically, as we talked about, process, manufacture, composition of matter, a machine. So some funny patents. Eddie Van Halen, the famous guitarist, he had a patent on, if you can see this stand that he had, which helped him play guitar the way he did. He had a patent on that, how that thing works, essentially, what's the functionality of this thing. The king of pop, Michael Jackson, had a patent on the shoes that he used in Smooth Criminal to actually do his slant dance. So basically, these shoes had a hook, which would hook in, had like a recess that would hook into hooks that were provided on the stage. You never saw them, but he would hook his shoes into them, and then that was able to do him the slant. And then there used to be there's a patent on a method of making a cat play, if you can believe that. The patent really is, there's a guy, he has a laser pointer, and he's moving the laser pointer around, and the cat is dancing. And that's the patent, a method of making a cat play. So I think it's tough now to get such kind of patents, but there was also a patent I saw on making a kid swing on a swing. Imagine that. So let's break down the patent, different parts of patent. If you look at a patent document, a patent, you have the patent number of top, you have the date of patent, when the date of patent means when the patent was actually issued or granted. You have information about what the name is, who the inventors are, what's the application number that was originally awarded, then other codes, and you have a list of all documents that was cited during prosecution. Prosecution really means the examination phase. Whatever documents the examiner cited is listed. And then, here's the filing date. The filing date is, was when the patent application was first filed. If there was a provisional application filed before that, you would have the filing date for the provisional as well. And everything before the provisional then is what has been used against this patent. So the inventors, per US law, inventors are the owners of the patent generally, and equal owners. If you have multiple inventors, each inventor is an equal owner, and each inventor has the right to use the patent in the way they want it. For large companies generally, or even small companies, what people do is you have inventors, and the inventors then assign their patent to their company. So the company owns the patent, though the inventors are different. And the company then, that's how Google has tons of patents. Google was not the inventor. The inventors assigned the patent to the company. There's a small section called background. Some patents you won't find. There's no set pattern to it. There are some requirements the USPTO requires. It requires a description. It requires some figures if necessary, and it requires something called claims and then an abstract. Background is not something that is required, but it's most of the applications there. You'll see in a lot of patent applications a long background talking about, like, a lot of people write it like, a lot of, again, attorneys come from science backgrounds or engineering backgrounds, and they write it like they would write a paper. But a background in a patent is a legal section. It's not a technical section. You basically, anything you write in a background, you're accepting that this was done before you actually made your invention or filed your application. And so you have to be very careful. If you say something in the background just to make it look flashy, that something that was done before your patent was filed, the patent office is going to take you on your word and hold it against you. So when I draft applications, our background section is very, very generic, very, very short. You have a summary section. Again, this is not a requirement. A lot of some clients and even some law firms don't even have that section. Some people write this section like an actual summary, like you would write in a journal paper or a project for a middle school or high school project. For a patent application, in my practice, we generally write it in a very legalistic way. We just pretty much just cite the claims of the application, and we'll talk about what claims are. Um, Often tracks independent claims. So we'll come to claim, but claims is really where you're in the section of the application, we're actually claiming what your invention really is. So we have drawings and figures. You will see all these numbers. Generally, the USPTO requires line drawings, but if you have good enough pictures, images, you can use them. For example, a lot of biological chemical patents have data in it. So you have plots in them. You have maybe microscope images to show something how it looks. Quite a lot, quite a few times we convert papers into patent applications. The key thing to note is if you are going to talk about, if you have come up with a new idea that you think is new, if we have on our researchers or professors or people who work in laboratories who also give publications or present posters at conferences. If you have something that you remotely think is new, always talk to your either your company's legal or whoever handles invention disclosures, or if you work with an attorney, talk to them. Because if you show something in public, if you present a poster at a conference, and then now you want to file a patent, basically that particular talk or publication that you did is your first disclosure, your first original disclosure, or public disclosure as we call it. If something is publicly disclosed, in the US, you just have 1 year. Within you have a 1 year grace period to file a patent, but you could lose patent rights in countries like Europe, maybe in China. They don't, you have first public disclosure, it's no longer patentable because it's public knowledge. So you want to file your application. If you have any idea, you want to file at least a provisional application before you disclose anything public. Coming back to the slide, you have drawings, you have reference numerals, you name everything. We call them weird names. Maybe I would call the handle of the guitar not basically a longitudinal member connected to a bass. And this is the bass, the basic guitar bass, and then a plurality of for the strings, I'll say a plurality of stretchable longitudinal members, something like that. And for this, we'll say an orthogonal structure extending from. So this kind of languages we use, and we name them all with numbers and refer to them by those numbers in the application. Detailed description is what analogous to your basic entire description of your of a scientific paper. This is where you describe the invention in sufficient detail. Should include what each inventor believed to be the best mode. This is kind of a quasi requirement. It's not really, it's kind of tough to say what's the best mode, but enough details in there somebody else can actually make and practice it. Does not define the scope of the invention. Scope means which area. So for example, you made a microfluidic chip and you want to test blood on it. But then the same chip can be used for neuronal cultures, or the same chip can maybe somehow or the other find a place in an automotive technology. It doesn't limit it to that, unless you say it so. So we tend to broaden the language out that the core technology can be used in a lot of different applications. So it's not limited to individual examples and features until you say so. So that's where, lawyers make their money, I guess, putting in language so as not to limit something to a particular examples or features that are in the application. And once the application is filed, it's filed. Very rarely can you add anything after an application is filed. So once you file it, that's all you have. No more adding or subtracting, maybe just minor corrections for clerical errors or some other small things. But once it's filed, and that's it. So if you after filing your full application, 1 day later you call me up and say, "Hey Raj, I missed this figure. I want to add this in." Hard luck. That's why we file provisional applications, because when you convert the provisional into a full application, you can add a lot of stuff at that point in time and make it more proper and add anything. So if an idea is half-baked, And if something has to be disclosed very soon, better practice is to file a provisional and then perfect it over the year and then file a full application. Also, if you don't have money, if you're a college student and you have a great idea, don't have enough money, you want to team up with other people, maybe if you can raise $200-300, I think you can file a provisional application for less than $200. You can basically file anything as a provisional application. Even this slide deck that I'm presenting right now, if I say this is a unique method of presenting, I have a unique method of presenting a slide deck to an audience, then I can file this entire thing with maybe something as in the patent office as a provisional application. But when you file a non-provisional, that's when you have to have all those things that we saw in the previous slides. Then you have, again, you have brief description of the drawings where you just talk about what the drawings are, or maybe 1 or 2 sentences about what the drawing is describing. Then you have a final section called abstract. It's a brief summary of it. Again, when we draft patent applications, we write it in a very legally manner. We don't draft the summary section like you would do a summary of a research article or of a school project, but similar to that. And finally, the most important section of patent application is the claims. And this is what defines what you consider to be the invention. So in the case of Mr. Eddie Van Halen, the key thing, if you look at the slide, is this slab, which rests against his thigh, I guess, and helps him, allows him to hold the guitar in that position and use both fingers. So in this case, maybe I have a claim where I talk about a playing instrument having a bass, which is the bass of the guitar, an orthogonal arm stretching axially away from the bass, plurality of strings on it. Maybe don't even talk about the strings because maybe it's a piano you want to use it for. So some generic word for describing some engaging member, and then then another structure extending orthogonally away from the base. I know that's the boring part, but that's what the claim language sounds like. And this orthogonal structural member structured to rest against the thigh of a user to allow the user to hold the playing instrument in a horizontal position, for example. So that would be what you're claiming to be an invention. So again, in the claims, you describe what the invention is. It can be an apparatus, a method of manufacture that we talked about. For example, apparatus could be a mousetrap. Method of manufacture, method of making a mousetrap, can be a method of use, maybe how you use the mousetrap, how you maybe set a mousetrap. For example, you have those rotating mousetraps now, or something with a vertical pulling thing, or maybe those all reliable spring-loaded mousetraps. Composition of matter, again, drugs, for example, Gatorade formula, what's the composition of that? Can be a gene sequence, can actually be a living organism. So you can actually, if you made a new bacteria, synthetically recombine DNA to make a new bacteria having a new DNA sequence, maybe you can, essentially you're claiming that bacteria with the new gene sequence, maybe a new virus. So, that you made for, a synthetic virus to, which can be used as a vaccine for the COVID disease. Independent claims are key. So in the claims you have, you can have any number of claims in the US. These are like, a claim is one long sentence with semicolons or commas, and it just one long sentence in legal language covers your invention. Independent claims are your broadest claim. That's what's the minimum thing that you need to describe your invention. Then you have something called dependent claims, following the dependent claim. So each dependent claim narrows an independent claim. In the US, you generally, without paying any additional fees, you can have 3 independent claims and 20 total claims. Any more independent claims or any more total claims, you have to pay additional fees. In Europe, maybe you have less. If you infringe one claim, you infringe a patent. Let's do a short quiz. If anybody wants to answer this, please turn your mics on. So we have a patent claim. The claim is claiming a mousetrap comprising. The term comprising is a broad term. It means you can have more components than what's listed. So a mousetrap, it comprises a base. That's one first part. a coil spring, and then a bar loaded by the coil spring. So that's your claim. That's your patent. There's a product on the market, which is a mousetrap, but it has a beige colored base. It has a coil spring, and it has a bar loaded by the coil spring, and has preloaded bait on it. Do you think this product infringes our claim? Anybody? Zunduran?
Thanks for product one.
Yeah. So do you think product number one infringes patent claim one?
I think so.
Yeah, you're right. So though it has a beige colored base, our claim doesn't say the base can be beige colored. It just has to be a base. So this product has a base. And preloaded bait, well, it has an additional thing, but still has all the things that described by patent claim one. So this it would infringe. Now you have another product. This has a base. It has a leaf spring and a bar loaded by the leaf spring. Do you think this infringes? Product number two infringes. And the infringement means that it reads on your patent, so you can assert your patent against that product and hopefully make money. So you think product number two infringes claim one? Anyone?
No.
Yes, and correct. And the reason is that in this case, you have a leaf spring, not a coil spring. That's something that is different from claim one. Now, this was your independent claim. Now your patent has a dependent claim, which says the mousetrap of claim one, wherein the base is blue. Do you think now product one infringes claim two? So how you would read this is basically read the claim one and then claim two as one complete sentence. So you have a mousetrap, it has a base, a coil spring, and a bar loaded coil spring, and then the base is blue in color. That's what claim two is adding to claim one. Now you have product number one, you have a beige colored base. Do you think product number one infringes claim two? Anyone?
No. It does not.
It doesn't. Yes, you're right. It doesn't infringe. It doesn't matter though, you are infringing claim number one. So you can still assert your patent. The other issue is that difference in color is really not changing functionality. There's something called doctrine of equivalence in patent law. So if you have something and you might not only just cover beige colored base, the color doesn't add a lot to it. So you have the base is blue in color, but you can also get any variations of that color unless you specifically mention blue color for some reason. For example, if the blue color is something which attracts the mice and there's a specific function for that, but your mousetrap has beige color because that beige color, in your opinion, attracts the mouse or does some other functionality, then maybe you don't infringe. But generally the patent office will say, well, the color is not, really has a big impact. We will consider all different color variations. But again, in this case, product one already infringes claim one, so it doesn't matter. Moving on, is claim valid, patentable? That's like once you have a patent, you think about what was actually valid? That is, was it granted accurately? Was there something the examiner missed? Again, patentable means the same thing. So when basically if something has been done before and you have a patent on the same thing, you can patent it. So it doesn't need to have been patented before, it just needs to have been done before. So all research articles, anybody public speech which mentioned your technology and you ended up filing a patent on it, though the old technology wasn't patented, doesn't matter. As long as something is in the public domain, you can file a patent on it. What means by prior art? When we say prior art, prior art means everything that can be used against your patent to determine whether it's patentable or not. So patent and patent applications, the USPTO mostly uses them. Journal articles in a lot of biological or biochemical patents. We see a lot of articles cited by examiners at the patent office. Ads, sales. So if something you sold something in the market, you have something in a car, the car is being sold, now you want to file a patent, well, it's already being sold. If it's been more than 1 year, you can file a US patent. Public disclosures, demonstrations. You have a trade show tomorrow. You have a conference tomorrow. You want to go to the conference, present this new paper on this great thing that you have done in your lab. That's a public disclosure if you disclose too much of it. And if you didn't file a patent, maybe you have 1 year to file a patent in the US, but you might lose rights in Europe. or China. Patent invalidity, this is basically once a patent has been granted, if somebody sues you for patent infringement, let's say Tesla sues Rivian or Apple sues Samsung, the first thing Samsung is going to try to do is invalidate Apple's patent. They will say, well, the patent that was granted is invalid. And then they will file something called, some kind of litigation. Let's not go into those details. And they will say, well, either everything is anticipated by what we found. Same strategy is used by the patent examiners. But what invalidity is, it passed through the patent office. Of course, patent examiners have limited time to do their search, and they might have missed something. When you do litigation, then they do a lot bigger search, and then they, try to invalidate something which is already been patented. Patent is invalid if all features of a claim can be anticipated. Anticipated means everything that's been done is present in some previous public disclosure or single reference. And the second is obviousness. Obviousness means something is not present in one single reference, but if you take two references and combine them together, you will get to this particular claim. For example, you have a patent on a four-legged chair and having a back, like I'm sitting on the back and relaxing, right? Now, you have a previous patent which shows a stool having four legs, but doesn't have a back. But then you have another patent where you have a bench, maybe not a bench, but maybe some kind of bench which doesn't have legs, but it has a back. And the examiner says, well, you take this four-legged bar stool and you take the back of this bench. In this pattern, you combine them two together, you get your chair with a back. And that's what obviousness is. And those are tougher because then you have to make legal arguments or try to find why somebody wouldn't think of combining the two. Key date, again, your first application filing date. Everything before that date is what the patent office can use. Even if it's something that you yourself disclose, apart from a few exceptions, even if you file something, it can be used against you. But that's why the filing date becomes really important. Final small quiz, validity. Let's see if these claims are valid. So you have a claim one, you have a mousetrap which comprises a base, again, a coil spring, and a bar loaded by the coil spring. The patent has another claim. You have the mousetrap of claim one, but now it also has the beige colored base. So you have a prior patent which discloses a mousetrap with a green base, a coil spring, and a bar loaded by the coil spring. Do you think claim one is invalid? Does anybody think claim one is invalid over what the prior art teaches?
It seems so.
Yes. Hello?
Yeah, it seems so that it is invalid.
Yes. Most probably it's invalid because you have a prior art it does teach a green base, but it's a base. You have a coil spring and a bar loaded. Our claim one talks about just a base. But when you talk about invalidity, you have to knock out every single claim, not just one claim. You have to knock out every single claim. So in this case, the claim two talks about a beige colored base. And what the prior patent is teaching is a green base. Do you think in this case, it's claim two is invalid?
No.
Yes. No. Did I hear no? No going one, no going two?
Yeah.
It on the face of it, it seems like claim two is valid because you have a beige colored base and the prior patent is teaching a green base. However, most probably when you file a litigation saying claim two is invalid, you'll most probably make an obviousness objection. You'll say, well, prior art, although it teaches a green base, it would be obvious to have a base which is beige colored because a color doesn't perform a function. Or maybe your prior art is teaching that a green base attracts mice, but another color which can attract mice is beige color. So most probably claim two would also be just a color difference. Now, if claim two said, a bar is loaded to a particular tension, or say claim 2 said a leaf spring rather than a coil spring. Most probably it looks valid, at least for an anticipation issue. It still might be obvious, but maybe you said a leaf spring, there's something about the leaf spring which makes it different. So that would be a different case. That said, again, wrapping up, if you have a new idea, it might be patentable. Do not disclose it to anyone who is not an inventor if you have a new idea. Document the new idea, date and sign it. A lot of labs I know are doing it. Professors do it. But even as a student in your high school, university, don't call all Snapchat all your friends and say, hey, friends, this is my new idea I came up with. I'm going to get a patent. It's public disclosure once you do that. Do not do that. Document it. Do a search for prior art. Of course, people are not as sophisticated. It's tough to do a prior art search, but it's not that difficult either. There's a patents.google.com, free patents online. We actually use these quite often. We have specialized software, but these will work. Just do a quick search. If you have a new idea on some whatever unique thing you have, maybe a new cover for a phone, new maybe handle for a phone, sketch it out maybe. If you can't find anything within 2 to 4 hours of search, it's difficult because patent use like complicated language. So you might not be able to find it. But generally, doing a Google search, doing a specific search for patents will give you an idea. If you don't see anything within a few hours of search, or even in a day or two of search, there might be something there. Write up a basic description and sketch some figures. Again, if money is an issue, go to your parents and say, hey, can you get me $500? Don't tell them the filing fee is $200, $300 your commission for being smart, but you can file a provisional, and then if you can raise more money, then you can file an actual non-provisional application. I filed one for my daughter who is 8 years old and came up with an idea, and this is my own patent we have filed with my 2 daughters and me on it. Give them an experience, but make them it's an honor. It feels like an honor, like in the movie PK, where that's not as big of a stretch. The lead character having 400 patents. Pankaj Bangru, I think, whatever the name of that character of Amir Khan was. But anyways, and then save money to hire attorney for the full application. Don't file a full application on your own. Get an attorney. And that's it from me. Questions again? I think some of the things that Shakil Bhai talked about was, if you look at my career, if you think you're going to see me as a patent lawyer in 10 years time, maybe not. You might transition to something different. One thing I've learned is my dad did his MBA when he was 58 years old. Passions change. Try to find a passion, or if you don't know what your passion is, try to develop a passion for the work you do. You'll enjoy it. If you don't have a passion for it, you find something new, interesting. Don't ever think it's too late for it. It might take risks, it might take sacrifices, but I know friends who have gone to do an MD with 4 kids at the age of 42, and they've sacrificed, but you feel more rewarded. Even if you fail, you fail. But in this country, we are blessed to live in the United States. And one of the beauties here is there's no age to do what you want to do. You just have to want to do it. That's it from me. Over to you, Shakil Bhai.
Very nice. Very, very good. Thank you so much, Dr. Haque, for your very insightful talk. Very informative. I learned a lot today as well, because I was part of another organization a couple of years ago, and this provisional patent filing and this non-provisional patent filing was a little bit of a black hole for us. So I think today I got a lot of clarity on that. So thank you very much for that. We have a few questions. The first question is, if you want to protect your product or idea globally, is it necessary to file patents in USA, Europe, and everywhere, or how does that work?
So generally, if you want to protect, first of all, if you want to protect your patent in every country in the world, be ready for $1 million. But generally, the idea is, if you want to have global protection, but you don't want to file a patent in each single country, there's a patent called a patent, international patent, or a PCT patent. So you can file a PCT application directly. You can file a provisional in the US or in any other countries who are signatories to the PCT. It's called the Patent Cooperation Treaty, PCT. You can file a provisional application in the US. After 1 year, you can file a PCT application within that 1 year. The PCT application is basically just an international application. It's examined, but it doesn't give you automatic right in all the countries. 30 months from your first filing date. So you filed a provisional on, let's say, January 1st. By January 30th, instead of filing a US application, you file a PCT app. You can also file a US application as well. You can file as many as you want with the PCT. But let's say you just filed a PCT application. So 30 months from January 1st, within 30 months from January 1st, 2020, you have to decide which countries you want to nationalize your patents in. And then you pick the countries. And that has to be a business decision. That for a lot of universities, professors want to get it patented in every single country. It's extremely expensive. So in the US, a full patent process, if you go through a reputable firm, can cost $20,000, $25,000, just the US patent. The PCT filing can be maybe 500, I don't remember, depending upon what size your company is. If it's a large company, it's more expensive. It's small, sole inventors, small businesses, slower. But then nationalizing it. So if you nationalize in the UK, you don't have to worry about translation costs. But then you have to have a UK attorney to deal with the patent office in UK. When our client instructs it, we send it to all our councils in those countries that we have connections with. Now, if you want to file in Germany, now you have German translation costs. You want to file in China, you have Chinese translation costs. You have Chinese filing fees. You have Chinese, fees for their attorneys. You want to file in South America, you have to now have filing fees. So you have to look at first from a business, the business strategy and the IP strategy need to go hand in hand. Look at what your market is. So if you have a company like Tesla, they're going to be maybe doing manufacturing in China. I'm pretty sure they're filing patents, if they are filing patents in China. One of my biggest clients, Cummins, we file a lot in China because we have manufacturing facilities. We file a lot in India now because India, you have manufacturing facilities. No translation cost. Indian prosecution is in English. We file in Europe selectively. If something has more of an application in Europe, then we file in Europe. Otherwise, maybe don't. Maybe in UK. If you file in Europe, means there's also something called a European patent, which doesn't give you right on all of Europe, but gives you right to nationalize again, like the same thing like a PCT in individual countries. So know what your market is, know how big the market is, and then decide on filing. I think most people would want to file in the US first. That's the biggest market in the world in terms of economy. Maybe Europe afterwards, if you have a big market. Maybe China, if you think you're going to get a lot of competition or there are going to be sales in China. But if you're worried about knockoffs, you can have being imported into China, into US, then you can just have a US patent and prevent importation, but prepared to file a lot of litigation. So
excellent. Thank you.
I see a lot of questions. Can you read them for me, Shakil Bhai, so I can go one by one?
The next one is if a PhD student is working on a project and there is a possibility of an innovation, would you suggest to the student not to present their work at conference and not to publish their work in journals, etc.? Are patent applications encouraged in US universities?
Yeah, so no, you should definitely present. The idea is patent coverage should not prevent you from presenting. It's just that if you have a new idea and you think it's patentable, before you present it, you should try to file a patent application. Most big universities, and even some smaller ones, have something called an Office of Technology Commercialization. And they might have different names for it, Office of Technology Commercialization, Technology Transfer Office. Every university has that. Talk to your professor. Your professor is most probably going to be a co-inventor. Though inventors is different from journal authors. You actually need to have contributed to the conception of one of the claims. That's what the definition of an inventor is. So simple, somebody like your research, like Samir Bhai, if you have come up with an idea and one of your students have contributed, but then there's a research scientist who's just doing the experiments. That experimenter may be a co-author. If all he's done is experimental work, he cannot be a co-inventor. But it would be tough for a student to say my professor is not a co-inventor. So, but because yeah. So, but you need to reach out to those offices. You file generally the process is you file an invention disclosure with that office of the university. Or if it doesn't, if it's a small university, maybe go to whoever the legal office is over there. and they decide then. So if a university has a procedure that it will pay for filing of applications, but then it will own the rights, then they will decide upon it whether this is something which is valuable or not, and they will make a decision on that. You have to make a convincing case. Generally, if you have a famous professor, then the Office of Technology Transfer will just move the head down and accept it on face value because the professor has a lot of pull. But if it's a smaller junior professor or just a student going, he might have a little bit of an uphill battle. But you can file an application on your own. Remember, depending upon your employment contract with a company or your student contract with the university, generally anything you do, like for example, Purdue University, everything that you do during invention you make while being a student at Purdue generally is owned by Purdue. I think University of Wisconsin-Madison is an exception where everything that is invented is owned by the inventors. But then I'm not sure if Wisconsin actually pays for patent filing fees and all that. But that's the route you take. Go to the Technology Transfer Office, file an invention disclosure, and then push them to file an application saying, I have a disclosure on this date, I need to file it. Now, if you're only going to file a US application, then maybe you don't worry about that too much. You do it and then you come back and file it. But if you think about Europe, and universities don't file internationally that much because it's very expensive. Okay.
Great.
Hope I answered that question.
Yep. Thank you very much. Next question. What's the best source for doing a patent search for infringement or violations?
I would suggest, you can do, again, google.patent.com is pretty decent now. There's another website called freepatentsonline.com. If you can make a free account. It gives you a little bit, there's a look at some of the other options. It gives you basically search strings you can add. So, and Boolean operations and various things to do a search. One thing I found while doing a search that helps is don't keep typing keywords and just looking through it, type another keyword. Make a log of the keywords that you first typed. When you find something interesting, before doing another search, look at what that particular patent cited and in which application it has been cited. And those options will be available. So instead of doing, look what this cited, look what cited this one, and then you'll generally start broadening and your prior art analysis or the hits you get, because it's very difficult to get good hits. We farm this out now to third parties to do it. One, it's less expensive. Some people can do it for less than $1,000 a prior art search for pretty decent one. And we do it from them because it's way more cost effective for us, and they're specialized in that. But yeah, you can do it on your own. Google.patents again and free patents online.
Great. Okay, that's it from my side on the chat box. Anybody else has any question?
I saw there was a question about how expensive is full patent filing. So in the US, let's just focus on the US. In the US, filing, there's two costs associated with patents. One is the patent office fees, right? So if you're a single sole inventor, it can be less than $200 to file the first application, but then you get an examination report that's called an office action. You get a non-final office action, you can respond to it. Then you get a final office action, and that's when prosecution ends. To reopen prosecution, you have to file something called another fees after 2 office actions generally. And that can be maybe $500-600. So, but generally you want to go with an attorney. So if you go with a small attorney, maybe if you're very lucky and something very new, maybe less than $10,000. Generally, a good patent application takes about $15,000 to $25,000 in the US. And that includes major cost is the attorney fees.
Okay. Do you see any other question directly?
Okay. I think that's it.
That's it. Okay, very good. If nobody has any more question, I'll simply say that this was one of the best webinars. Dr. Haque, you did an amazing job. Thank you very much. We learned a lot. I hope everybody enjoyed. And this talk will be available on Facebook and then on YouTube. I'll send you, Dr. Haque, the link to the recording, and you can share with your friends and in your circle. And again, I'll just end with this reminder that STEM matters. Our mission is to inspire students to excel in science, technology, engineering, and environment matters. by nurturing their critical and analytical thinking skills. Our spring 2021 cohort enrollment is open now. You can find more information about the enrollment on our website, STEMatters, STEMatters.org, and go to programs and then select spring 2021. So with that, Dr. Haque, thank you very
Somebody had
much.
a question about sharing slides. Unfortunately, I'm not sure I can share these. A lot of this is what we use in my firm when we talk to clients. So being in the legal profession, we are, as you say, eternal pessimists, and we always fear of the worst. So I don't think so I can share these, but if you have any questions, feel free to reach out to me or Shakil by any connected.
Yeah. Okay, with that, thank you all. Appreciate it. Have a good, wonderful day, rest of the day today. Take care. Bye-bye.
Allah Hafiz. Bye.